One.
Alex.
Good afternoon and welcome to this news event hosted by the Piaba Foundation. You'll be hearing from 4 speakers today, and then we'll open the floor for questions during the Q&A period. The Q&A period will be for reporters only, and if you wish to ask a question, use the raise your hand function and your line will be unmuted when it is your turn to ask a question. For more information or to follow along with today's news event, you can go to the Piaba Foundation website. That is piabafoundation.org. Piaba is P-I-A-B-A. That's where you will find today's news release and report. I'll also be dropping a direct link into the Zoom chat box here shortly, so please be on the lookout for that. As I mentioned, you'll be hearing from 3 speakers today, and then an additional during the Q&A section. Our first speaker today will be Piaba Foundation President Jason Doss. Our second speaker today will be Piaba Foundation Vice President Lisa Briganzo. And our third speaker today will be Piaba President David Meyer. And as I mentioned before, we'll be joined in the Q&A session a little later by Alabama Securities Commission Director Joseph Borg. Why don't we begin with our first speaker, that is Piaba Foundation President Jason Doss. Jason, take it away.
Good morning. As you just heard, my name is Jason Doss. I'm the president of the Piaba Foundation. I want to welcome you to this news event jointly sponsored by the Piaba Foundation and the Public Investors Advocate Bar Association, or Piaba for short. As a little background, the Piaba Foundation was formed in 2012, and our mission is to protect investors through education. We do this in part by providing educational materials that are designed to prevent investment abuse and raise awareness about Finra's securities arbitration dispute resolution process. As you will hear from our moderator, the new report and related materials for this event can be found on our website at www.piabafoundation.org. For more than 14 years, and over the course of 3 studies released in 2013, 2019, and now this one in 2021, the Piaba Foundation and Piaba have studied Finra's processes and procedures that allow brokers to expunge customer complaints from their publicly available background information. We have produced 3 studies looking at over 3,300 expungement awards that were issued between 2007 and 2011 over that 5-year period, 2015 to 2019 during that 4-year period, and now this one, 2019, it's August 1st, 2019 to October 31st of 2020. All 3 of these studies are also available on our website. Our new report today shows that over the last decade, very little has changed in the expungement process to protect investors who rely on BrokerCheck to research the backgrounds of brokers before they select them to manage their life savings. There's also been little change to protect state regulators who rely on the complaint histories of brokers to perform their regulatory functions, such as deciding whether to license a particular broker in their state. Our conclusion from this study and the others is that Finra's expungement process allows brokers to erase valid customer complaints, and that arbitrators who decide these requests still grant expungements at 90% of the time, when expungement was and is intended to be extraordinary relief. In this new study, after analyzing now 700 more expungement awards from August 1st, 2019, we found that Finra's proposed rules to change the process that are headed to the SEC to be reviewed and approved or not by the SEC on May 28th, those rules changes do not fix the problem. And the proposed changes will not reduce, ultimately, the unacceptable high rate that arbitrators are granting expungement requests. In our view, significant new steps, including the creation and embedding of an independent investor advocate into those expungement arbitrations that would be empowered to oppose expungement requests needs to be taken now, or we're going to be back here in another 5 years or 7 years talking about the same problem. Key findings of the new Piaba Foundation Piaba joint report include the following. One, more than 1,000, has been over 1,000% increase in the awards issued in these straight-in expungements from 2015 up to the present. There was 59 straight-in expungement awards in 2015, and now there was 700 of them just in the last 15 months between August and October of 2020. So a straight-in expungement is a request made by a broker where they've named their broker-dealer or current or former broker-dealer as a respondent in the arbitration process. The customer who complained is not named. And so that's what I'm talking about and what we're talking about in the study when we say a straight-in expungement request. It's a request by a broker against a brokerage firm seeking expungement of a customer complaint. The second thing that we found is that the rubber stamping by arbitrators of expungement requests continue. Arbitrators have continued to grant expungement 90% of the time when it's supposed to be extraordinary relief. The next finding is the solution that Finra is proposing is to increase the number of arbitrators who decide these cases from 1 arbitrator to 3. And what our study finds is that's not going to work. 3 arbitrators are just as likely as 1 to grant expungement. And this is because the Finra's proposed rule change does not fix the problem, which is that brokers are able to provide these, make these requests unopposed by customers and state regulators. And that makes it all the more likely that an arbitrator is going to grant the relief. The rules make it easy to get expungement. It's difficult for consumers to oppose it. State regulators don't even have the opportunity at all. Even with this adjustment, the minor adjustments they're making in the new Finra rule proposals, challenges will not be made materially easier by these changes. The broken expungement process also sees few objections, and that's because customers and state regulators are not provided a meaningful opportunity to participate. But when there are objections, our studies found when customers did object or brokerage firms who are the respondents objected, it made a big difference. Brokerage firms object to expungements in these cases only 2% of the time, and investors only about 13 to 15% of the time. However, our 2021 report shows that arbitrators are 5.4 times more likely to deny expungement when the broker-dealer respondent opposes expungement, and they are 4.3 times more likely to deny expungement when customers oppose the relief. So, what's the answer? The Piaba Foundation in the Piaba report proposes the creation of an independent investor advocate that would be embedded into the process that could provide that check on those expungement requests. You will hear more about that from our second speaker, Lisa Briganzo. To wrap up my statement, I want to say this. The SEC needs to put this program under a microscope and take a very close look at our 14 years of findings. Right now, states and Finra jointly run the CRD database system, which is the underlying database that supports BrokerCheck that investors rely on to get their information about brokers. But states do not get notice. This is really important. States don't get notice about expungement requests until after they are granted in the arbitrations. Finra's proposed rule change does not go far enough on that point. It proposes to provide earlier notice to states, but there's no way for states to actually intervene into the arbitration process at the time where that decision is being made. This is a huge regulatory black hole. You'll hear more about this from Joe Borg later. That's just going to continue getting worse with every year that passes, unless it's fixed now. An investor advocate empowered to intervene to oppose expungements that represents all interested parties in relation to this expungement request is really the only way to fix this system and keep thousands of additional customer complaints from being wrongfully erased from the public record. States can only regulate the broker's conduct that they can actually see. If it's been erased, it's too late. And investors can only avoid problems with brokers if they're informed about their background. Thank you for your attention to my remarks. I look forward to taking your questions.
Thanks, Jason. Again, that was Piaba Foundation President Jason Doss. That takes us to our second speaker today. As Jason mentioned, that is Piaba Foundation Vice President Lisa Briganzo. Lisa?
Good afternoon. My name is Lisa Briganzo, and I'm the Vice President of the Piaba Foundation. I'm pleased to have served as a co-author of this report that we're releasing today. I'm going to be focusing on the major solution, the step that we've outlined in the report to solve this problem. But before I do that, I want to provide the context for this major recommendation that we're making. As you listen to the key findings that Jason outlined, and as you read the report, you'll notice one main theme running through it. The relationship between the broker seeking to have his or her record expunged and everyone else, including the customer who made the complaint, the brokerage firm that's responding, state securities regulators, and even the U.S. Securities and Exchange Commission is out of balance. We can see how out of balance the expungement process is, and Finra observes this at times by the lopsided results. 1,000% increase in expungement awards, arbitrators granting 90% of expungement requests, and most tellingly, almost a complete absence of opposition to broker expungement requests. Brokerage firms oppose expungement only 2% of the time. Investors appear and oppose expungement only, as Jason said, 13 to 15% of the time. State regulators can't even get into the process today because they only get notified after the expungement award. They only get notified of the expungement after there's an award. Think about that. The states and Finra jointly run this CRD system that contains this important information, customer complaints. Yet Finra unilaterally makes the rules about when and how customer complaints can be expunged. Finra's proposed rule change would give the states 30 days notice of a broker's filing of a request for expungement, but under the proposed rule, the states don't have a right to intervene, to oppose expungement. So this part of the proposed rule accomplishes kind of nothing. So let's focus on the step that we propose in the new report. If Finra is going to continue to have an effective monopoly on this expungement process, we need to have someone who is responsible for minding the store, for making sure that genuinely valid customer complaints are not erased from the public record. So how do we do this? We make someone responsible for defending the integrity of the CRD system, the regulatory record. That's why the SEC or Finra must create an independent investor advocate whose charge is to ensure that only customer complaints that have no investor or regulatory value are expunged. As our new report says, the Piaba and the Piaba Foundation recommend that Finra and or the SEC create and embed an advocate into the expungement process, similar to the role of a guardian ad litem serves in a court case. The purpose of the advocate would be to protect the broker check CRD data, which the investing public is encouraged to rely on as current and accurate. So here's the reality today. We have an expungement process that's been out of control and is getting more out of control. Now, the problem we have today is brokers know that they can win the expungement lottery 9 out of 10 times. It's literally open season on these public records that investors need to be able to identify bad brokers and avoid them, and that regulators need in order to police the marketplace. The fact is, BrokerCheck and CRD are no longer reliable resources for investors or regulators. In closing, I just want to share a few thoughts. While we appreciate that Finra has taken a number of steps over the years to address the abuses of the expungement process, the bottom line is that the current Finra proposal to the SEC just isn't good enough. As a result of expungement abuses, the public records of hundreds of brokers, including a number of genuinely problem brokers, has been wiped clean. Regulators, investors, brokerage firms, and the public have lost customer dispute information, including disputes that were settled for not just hundreds of thousands of dollars, but sometimes for over $1 million. Those have been wiped out. Something has to change, and we think we have the answer. That concludes my statement. Thank you for joining us.
Again, that was Piaba Foundation Vice President Lisa Briganzo, and that takes us to our third and final speaker today, which is Piaba President David Meyer. David?
Good afternoon. My name is David Meyer with the law firm of Meyer Wilson. I am the president of the Public Investors Advocate Bar Association, Piaba. A little background about Piaba. We are an international bar association whose members represent investors in disputes with the securities industry. The mission of Piaba is to advocate for equal access to justice for investors in all forms. Piaba also works toward improving policies, regulations, and laws designed to promote investor rights and prevent misconduct by those who sell investments to the public. And even though there has been tinkering in the margins to address concerns raised by Piaba over the past 14 years in the reports mentioned by Jason, the truth is, as Lisa referenced, the expungement problem has gotten progressively worse and it is abused more today than ever. And unfortunately, we just do not see how FINRA's proposed rules that are due for SEC consideration by May 28th will fundamentally fix the problem. Jason laid out the big picture for you. Lisa focused on the solution step. What I want to focus on are the consequences of an expungement process that has run amok. What these brokers are seeking to wipe away are investor complaints that go on file in the Central Registration Depository, which is maintained jointly by FINRA and the state securities regulators through their national trade group, North America Securities Administrators Association, or NASA for short. The CRD is significant in two ways. First, securities regulators rely upon it to identify and deal with problem brokers. And you can see the problem here immediately. If 9 out of 10 problem brokers can just go in and wipe out all the evidence of their misconduct, those state securities regulators are flying blind. Another big issue relates to what is called BrokerCheck. Maintained by FINRA, BrokerCheck is widely advertised and promoted as the primary way for individual investors to go online and check out their brokers before making a decision whether to hire the broker and trust him or her with the customer's life savings. And the existence of prior customer complaints is among the most important of the red flags that investors should be able to find when they consult BrokerCheck. But by letting problem brokers literally edit history through this expungement of the records, BrokerCheck is being undermined, and it often leaves investors with the false impression that there is no reason to be concerned about what are now thousands of brokers who have exploited the expungement process. So can someone explain to me why a broker or a brokerage firm who settles a significant FINRA arbitration case involving investment losses should be allowed to omit that information from the broker's regulatory records when another investor may evaluate that information to determine whether they want to hire the broker? What possible good can be achieved by sweeping all that under the rug? And FINRA's most recent rule proposals will not fix the broken expungement process. Regulators and investors will still be flying blind unless the major changes outlined in the report are made. Accurate and complete complaint history on brokers is also critical to preserve the ability of state and federal regulators to police the market and include identifying bad brokers. Thank you. That concludes my opening remarks, and I look forward to taking any questions.
Thanks again. That was Piaba President David Meyer. That takes us to the Q&A portion of the event. If you wish to ask a question, please use the raise your hand function and your line will be unmuted when it is your turn to ask a question. And as a reminder, the Q&A period is for reporters only. If you're having issues with your own audio or raise the hand function, you may use the text-based Q&A box, and we'll try to do our best to get to those questions, but we will try to take the raise your hand function questions first. And as I mentioned before, we will be joined in the Q&A session by Alabama Securities Commission Director Joseph Borg. And before we take that first question, I want to mention that a video recording of this news event will be made available online later today at the Piaba Foundation website, along with all the other media materials, including the news release and report. Again, that website is piabafoundation.org. All right. Let's take our first question from Andrew Welsh at Barron's. Andrew, please unmute yourself.
Hi, thanks for taking my question here. And thank you for taking the time to talk about the report today. I guess I just wanted a bit of clarity. Please pardon my ignorance, but so the way I understand it, they expunge a request and that takes it off a broker check. Does it also take it off the CRD? Meaning, you know, like Joseph Borg over there, will no longer be able to see it. Is that really how it works?
Joe, do you want to take this one?
Sure, I'll be glad to. Andrew, that is correct. If it comes off the CRD, then that is the central system from which BrokerCheck pulls its information. So it will not be, it actually is expunged off the CRD system, which means then I don't see it for a future license. And the BrokerCheck will not show it as well because BrokerCheck really is a subset of the information on the CRD. I hope that answered the question.
Yeah, that does provide some clarity. I'm a little surprised that that was the case. I always thought I understood that it was, while it wouldn't show up on BrokerCheck, that it still existed there and that in theory you could always see it.
Think of the CRD as the central system with all the information. And BrokerCheck then sets parameters of what it's looking for, and then that is created into the BrokerCheck that most retail folks look at. From a state securities regulator, we would look directly at the CRD, which may include some other information, some which may not be public, and others that may have more detail than what the BrokerCheck parameters allow for. So for licensing purposes, the CRD is what state regulators generally use to determine whether or not a license should be granted to a particular individual.
Can I ask you, sir, if I may just ask one follow-up question, just to you, Mr. Borg, based on your, sort of unique perspective where you're sitting there. Do you feel that you're being deprived of information that you would want to see as a state securities regulator?
Well, I would say this has been ongoing for quite a while. The information itself that's in CRD is jointly owned by Finra and the states, but the systems, the operational and procedural systems, the computers, the servers, and how that operates is operated strictly by Finra. So the states don't actually operate the computer systems itself. They happen to own part of the information along with Finra. So yes, there are issues. I do think, as I think Lisa mentioned earlier, that Finra is trying to move this along to some extent, but there are gaps. And we've had this conversation with Finra over the years, and we appreciate that Piaba has taken a direct interest in this. Certainly, I have an interest. Look, I'm a small state, so it could be that there's a broker from, pick another state, bigger one, and perhaps there were some issues up there, and perhaps there was an expungement, and now they decide they're moving to the South and maybe want to do business in Alabama. I would like to know what was on that complaint file completely, not just what's left, before I make a determination whether is this a person I want in my state to deal with my folks, asking them for their retirement funds? So I think it's an important concept that that record be complete as possible, except for the stuff that should come off, which are, you know, extraordinary remedies. Like, okay, it's the wrong John Smith. You know what? I want to get the right John Smith, not the wrong John Smith. So that comes on off. The factual situation that was given is impossible because, oh, the branch manager whose name didn't start work there till 2 years after the transaction. Yeah, these don't happen that often, but they do happen. And there are several other categories. But to say, you know, I want to get my record expunged. I'm a broker, and gee, I had one 5 years ago and three more 2 years ago and one last year. Now's a good time. Let me put them all together and hire somebody to get my record completely wiped out. And so I can start fresh, maybe in a new state, or maybe in a new part of the country, or gee, I want to go with another firm. You know, the firms won't see it either if it's not CRD. Interesting though, I think the firms do ask some of their folks, like, have you had anything expunged? I don't actually have that opportunity to do that. My licensing comes off the CRD. I hope that helps answer that question, Andrew.
It does. Thank you very much.
And just to follow up on what Joe said, this is a really important point, and which is something that we've appreciated even more as we've analyzed, you know, all these awards is, and it goes to what Dave was talking about, Dave Meyer, which is the impact. There's a huge regulatory gap here that these expungements are creating a very large blind spot for regulators to be able to evaluate whether to license a particular broker. And so the fact that they don't know about it until after the expungement award was granted by the arbitrator, and all that's provided is a notice saying they're going to go confirm this in court, the rights that states have to intervene in a court case to oppose confirmation of an arbitration award is fairly limited. Arbitration awards are meant not to be appealable, really, unless there's very narrow circumstances. So it's really important for states to be able to be involved and participate at the beginning during the time in which the arbitrator is considering whether to grant expungement.
All right, on mute there. Let's take our next question. That next question comes from Miriam Rosen with Advisor Hub. Miriam, please unmute yourself.
Hi, can you hear me?
We can hear you. Oh, we could hear you for a second.
Am I unmuted? Yes.
You're unmuted, yes.
What's been the response from Finra and any other advocates outside of the group that's here, outside of Piaba, that have been supportive of this?
So I'll take the first stab at this, and others can join in and say, so this rule proposal was introduced, I believe, last year, late last year, and there was a comment period that expired late last year. The foundation in Piaba, NASA, requested that the SEC have a hearing. So because there's a lot of moving parts here that need to be talked about, that the comment period, it doesn't necessarily translate on paper through these comments. And so we have gotten support. You know, the issue about the state's problem and that they want to be able to participate in these expungement proceedings is the position that NASA took in their comment request. So we're not asking for anything that the states aren't also asking for. Our only difference is that the investor advocate would have a broader purview than the state regulators. State regulators should be able to participate, but there's other stakeholders in the process that need to also participate, like customers whose complaints are at issue. The current system doesn't provide them with a meaningful opportunity to really participate in that process. They get notice, but you know, and we actually provided an example of how complicated it is for a consumer to try to represent themselves in these proceedings, and how one discovery issue which we provide an example of, would cost a consumer thousands of dollars to hire a lawyer to protect the integrity of the CRD database. And it's just not feasible for a customer to actually participate through a lawyer, which is why we created this pro bono expungement program that the advocate role that we're proposing would basically do as well. So anyway, so we've gotten support. There's support for this, and we're hoping that we can fix the problem now rather than continue to kick the can down the road with minor edits to fix the current problem of the day, which is the tactics that are being used in these arbitrations.
If I could ask two follow-ups, which is, who would fund the investor advocate, the embedded investor advocate?
So that's a great question. We envision that this advocate role could be funded in part by Finra. It could also be funded through grants being issued to help fund that source. It's the most cost-effective way to do it because the attorneys or the advocates that we're proposing are doing this work for free. And so Piaba members are literally volunteering their time to help customers oppose these requests when they want to. And it's a big undertaking in every case, but we're willing to do that because we care about the system. And I envision that the advocate role would have a similar function, and it would be funded through grants and through Finra as well.
Can I just jump in real quick? This is Lisa Briganzo, and I just wanted to mention that we do have the support of other organizations that advocate for investors, and that includes Consumer Federation of America that's expressed some support for what we're advocating, and we're very grateful to Barb Roper for that.
Great, thanks. Just one more follow-up question. Are there any workarounds that exist now? The states get, say, for example, U5s at the same time, right, that the firms file them. Could they, if there was like some kind of, I'm just imagining some kind of expunge, something has been expunged, could that then lead some kind of indication on any record, could then lead states to go and basically review what they did receive originally?
Joe, do you want to take this one?
Yeah, I'm not sure I followed the question exactly, but a U5 for termination sometimes just says voluntary. Sometimes it may be for cause. If it is a for cause, and that termination is there on the CRD record, unless that broker is about to move to another firm, let us suppose he's terminated for some cause, it's on the CRD, but he does not apply anywhere else. Well, at that point, he's not in the business any further. If he should immediately apply to another state, to a state or through the system again, and it is on the CRD, then of course that's going to be looked at by the particular licensing agency, maybe Finra or the states. However, let us suppose that in your example, it is on the CRD, but then it is expunged at a later date prior to the time of any application for a new license or to come back in the industry. If it is off the record and we don't see it, or I don't see it, then that'll probably go on through as an application based on whatever else is left on the CRD. Therefore, the issue of what that termination was for, the termination may be there, but the termination may not have sufficient details to indicate to us that there's a problem that needs to be looked at, because the action, which is usually a customer arbitration, is no longer there. If the firm has terminated them for some cause of a violation of firm policy and it is still there, then we'll take a look at it and we'll be able to review it. But that sort of depends on how the U5 is filed, what details are in it, the timing, has an expungement occurred after that date, what has come off, and what is left for us to take a look at. So there's a variation of factors. The fact that there's strictly just, hey, somebody left the firm by itself, I guess in my numbers with my state, there's about a 40% changeover from one firm to another in my registrants and the broker-dealer side in a given year. So just the fact that there's a U5 file by itself just means they've left one firm and gone and are looking to go to another or leaving the industry. So it depends on the detail that's filed with that U5.
Just
to Lisa Briganzo, can I just add one quick thing, Miriam? That the expungement process isn't for anything related to, or this expungement process is not anything related to complaints other than just straight customer complaints. So those get reported on the U4s. This isn't about expunging other information like bankruptcies or regulatory actions or anything like that.
Yeah, thank you, Lisa, for correcting on that, because I should have made that distinction and I did not. So thank you.
One more thing, and there's always confusion in terminology between a U5 and a U4. So the U5, as Joe says, just relates to a broker when they leave the firm and change firms. And the only time in which BrokerCheck reports a U5 disclosure for the reason for leaving is if it's investment related. So BrokerCheck further filters things down to really just information that was submitted on the U4. It does not include U5 termination language unless it's investment related. So, from the investor's perspective, the workaround you're asking, there is no workaround for consumers. Once it's erased, it's gone. And the same applies for states.
And can I add just one more thing? In some ways, this process, running this regulatory process through arbitration, is the workaround. So, I mean, the perfect answer, if we can have exactly what we want, we would want this process to be decided by regulators. Could be state regulators, could be a regulatory arm, within Finra, could be the SEC, but somebody who is just dedicated to making a regulatory decision about whether the information that relates to that customer complaint has regulatory or investor value. But we are recognizing that that isn't going to happen anytime soon. And so our proposal that we have an investor advocate embedded in the expungement arbitration process is really the workaround. I mean, we're kind of, making lemonade out of lemons here.
Thank you all.
Why don't we take our next question? Our next question comes from Susan Antilla. Susan, if you wouldn't mind unmuting yourself.
Are you able to hear me?
We are.
Okay. Thanks. Has Piaba ever considered just downloading all of the current data and then doing subsequent downloads, say on a weekly basis, monthly basis, so that you have your own database and you would have that stuff and so you would know what had been expunged?
So the answer is yes. I think that's been considered and thought about, but at the end of the day, Finra's BrokerCheck that doesn't fix the problem. If we had our own database, that's great, but we'd have to have, basically, you're asking us to compete and create a completely new BrokerCheck system, which may be a great idea, but it doesn't fix the current problem either, which is that Finra's BrokerCheck allows these complaints to be erased, and it's incomplete. So I understand the question, and I think that's a great thing to think about. But the solution shouldn't be, hey, just create your own completely new BrokerCheck system. We need to try to fix the problem at hand, and that still doesn't change the fact that brokers are allowed to erase these things, and state regulators are being harmed just as much as investors are.
Again, this is Lisa Briganzo. Can I point out one more thing? One of the other problems is we could do that, but then if you go to the SEC's investor.gov website, it points you to BrokerCheck. We would have to then convince the SEC that they should be pointing people not to the official broker check that's run by Finra, but to the Piaba or Piaba Foundation version of broker check. Otherwise, then we have to, engage in competition. We'd have to reach out to all the state regulators, many state regulators on their websites. They point people to broker check. They say investigate your broker before you invest. And again, we would have to, it would be a real effort to advertise and become, the successful competitor to beat broker check on for Google searches, and to get the regulators to move broker check aside and put the new version of it that we would propose out there.
If I could just ask one follow-up, it might not work as you're talking about it as something that investors could use, but at least somebody would have that information down the road. So if Joe Smith, the crooked broker, ends up in jail, you guys can say, yeah, and he had 10 items that were taken off his record over the past 5 years. So you could at least, there would be some integrity in that you would know what the backgrounds, there would be some place that even reporters could go to find out about these people. So just an idea.
And there is a way now via, somewhat via the public records, but you have to dig into arbitration awards, and you have to dig out which ones are the expungements. So, for example, if you happen to know a broker's name, you can look at broker check, and then you can, do searches on that broker's name in the arbitration database to see if there were any customer complaints, but also to see if that broker ever obtained an expungement award. Part of the problem there is, well, broker check is easy. It's one place to search. I've thought about doing this, creating, a system to tell people, okay, go to broker check first and then go to the expungement database. Here's the search you have to do. But you also have to figure out, a lot of people have similar names. And you have to wade through a lot of other things to be able to search that arbitration database. I mean, there's a lot more arbitrations in there. So you can't just figure out, oh, where's the expungement ones and does it involve this particular broker? It is possible, and it's possible that there are old versions of CRD out there through which there could be a reconstruction, but that's a pretty substantial effort, and that's just not something we've been able to take on via the foundation or Piaba at the moment.
Right. Okay. Thank you.
All right. Well, we want to offer reporters one last chance to pose their questions. As a reminder, to ask a question, use the raise your hand function and your line will be unmuted when it's your turn to ask a question. And as a reminder, the Q&A period is for reporters only. If you're having issues with your audio or raise your hand function, you may also use the text-based Q&A box, and we'll do our best to get to those questions as well. Looks like we have a follow-up question from Andrew Welsh. Andrew, please begin.
Yeah, I just wanted to follow up. Why don't more investors participate in these expungement cases? They have an opportunity, right?
I can address it first, and we can kind of go from there. It's a great question. So there's a number of very valid reasons that investors don't participate more frequently than they do. For one, and I'll take a subset of complainants, people who have actually filed arbitrations, and have sued the brokerage firm for whatever, unsuitable investments, whatever the complaint is. Once, and I've been representing investors now for almost 20 years. Dave and Lisa are similar. When an investor settles their case, they're done. They want to be done. The whole point of settling your dispute is that you're finished with this. And historically, the expungement requests were resolved in the underlying arbitration. This new tactic, these straight-in expungements, the broker waits until after the conclusion of the arbitration when the investor is done, mentally and financially done with that process, to then file a new one, calling that person a liar, basically is what they're saying. And then the investor has to relive this entire terrible process again. But this time, there's no financial incentive for them to do so. They have to pay a lawyer to go out and defend the integrity of the CRD database. Investors are not oftentimes willing to do that. That's number one. Number two, the timing of the notice is they don't have a lot of time to respond. And so, they'll get a notice maybe 30. Our last study in 2019 showed that the amount of notice that investors get it was sometimes a few days, a month before the actual trial that was scheduled to happen. And they get a letter from a law firm saying, hey, your complaint's going to be expunged. You can show up at this time. That's another problem, timing. In asking someone to go and go hire a new lawyer is not feasible. The third is the amount of information that they're allowed to get, even if they did participate. Once they get notice, and let's say they find the Piaba Foundation's expungement pro bono program, that's a plug for our program, the amount of documents that they're able to get are limited to basically the statement of claim without even the exhibits that are attached. So they don't even have the tools to be able to defend themselves in these proceedings, which is it's designed not for people not to participate. And I can tell you from experience, and I know Lisa can as well, when you actually show up at these arbitrations to oppose expungement, you're a speed bump. You're not welcome. And that's the lawyer who doesn't really care if people don't I'm professionally trained to not care if people like me or not. But an investor, to do that on their own, that's way too much to ask. That's why this investor advocate needs to happen. And so, that's a short answer. We could go all day about this issue, but this process, in short, is not designed for investors to participate in a meaningful way. And that, I think the numbers bear that out. It's not the investor's fault, it's the process.
And if I can jump in, I mean, even when you have an investor who is interested in participating, they have to get over hurdles. Like there might be a non-disparagement clause in the settlement agreement. Well, how is the investor going to stand up in Finra arbitration and say bad things about the broker without violating that non-disparagement provision? Now, whether that's enforceable or not, that's another issue, but that's something that an investor is going to worry about. What about a confidentiality provision in a settlement agreement or in a discovery order where documents were produced that were confidential? Well, now the investor wants to appear, oppose expungement, and use the smoking gun documents that came from the brokerage firm's own files. Well, the investor now has to contend with threats that they might be violating the confidentiality order. And that is something that we addressed in the report. We attached, that's our case study, and we attached exactly one of those threatening emails that we got. And that says, hey, if you use any confidential documents, then we consider that a violation of the discovery order. So here are all these things that, an investor is going to just back away. I mean, if they don't have a lawyer, they're going to back away. And frankly, if they don't have an attorney who knows this expungement process and knows that, FINRA really doesn't think that those kinds of provisions should be enforceable, they might just walk away too and say, no, sorry, you can't really oppose it.
Thank you. That explains a lot.
All right. It doesn't look like we have any additional questions today. I just want to make sure that you know where you can get more information about today's news conference. To connect with any of the speakers that you've heard from today, you can contact Myself, that's Alex Frank at 703-276-3264 or afrank@hastingsgroup.com. A recording of this news event and related media materials are now available online at the Piaba Foundation website. That is piabafoundation.org. I want to thank all of our speakers and all of our participants today for joining us. Again, this was a news event hosted by the Piaba Foundation, and that concludes today's news event.